Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Family Law. And today I'm here with attorney Michael Reid to talk about what community property is and how it impacts a family law or bankruptcy case. So Michael, before we start in, can you tell us a little bit about yourself?
Sure, Steve. Thanks. I am a Washington and Oregon attorney. I've been working with the Pacific Cascade now for just a few months. Prior to that, I had my own law practice practicing family law and bankruptcy. Prior to that, I was in-house counsel for a large utility for several years. And I enjoy playing the piano. Is that enough?
That is more than enough.
All right,
I enjoy
good.
listening to the piano. No one ever lets me sing with it because my voice is not, I guess, what they call good.
Recordable.
So, there you go. So today we're talking about community property. Washington is what they call a community property state. So let's just start with the obvious question. What is community property?
Okay, so there are 8 states that are community property states, from Louisiana, Texas, New Mexico, Arizona, California, Nevada, and Idaho, and Washington. And if you're in one of these 8 states, then the rule is all of the assets and debts that you acquire during a marriage belong to both parties of the marriage. That's all that community property means, is that everything is community property without having to say that it's community property. Other states are separate property states, and so it's not necessarily community property.
And we're not, I take it, we're not just talking about in a sense of how they're split at divorce or something like that, but they are actually held or considered to be held as in ownership by both of the spouses.
Yep, that's right. Yeah, and it usually comes up as an issue in family law cases. That's generally where we're going to see that. It could come up. It does come up as well in bankruptcy cases, and we'll talk a little bit about that. But it could also come up in, say, a consumer case where a creditor is trying to get money from one partner. Well, then you've got to consider whether it's community or not.
Yeah. Just to get it straight on my end, you said couples who are married, do they have to be married? Does the Washington registered domestic partner count as married, or just plain old domestic partners, or just people who live together?
Yeah, they do, and in fact, in Washington, the domestic partnership, it was altered. I think it was in 2014 that the law was altered so that anybody who was already in a domestic partnership as a same-sex domestic partnership automatically got converted to a marriage. So all of the rules apply to both. It also can apply even if you're not married or in a registered domestic partnership. We have in Washington, we don't have what's commonly called a common law marriage. Instead, we have a CIR, a committed intimate relationship. And if you're involved in a committed intimate relationship with the guise of being marriage-ish, then the community property rules they can apply as well.
Got it. Okay, community property owned by the spouses. And what about the other property? I think they call it the separate property.
Sure.
How do you know when it's separate property?
Yeah, you're going to want to have some things that are separate, and there are some things that are not community. They don't fall under that community property umbrella. Anything that was owned by, and I'm talking about property, but it's also going to be important that debts also apply as community. Yeah, but we're going to focus here on community property. So anything that was owned by one partner prior to the marriage continues to be owned by that partner throughout the marriage. And there are ways that something that is separate property can become community property. And in fact, the laws tend to push things toward that community property. So we can talk about that as well. Anything that is inherited is separate property. If somebody receives something because of a disability, then that will be considered separate property as well. But again, all of these things can become community property if it's, even if it's not intended to.
Got it. And so I imagine that the community debt that you talked about follows the same sort of rules.
Yeah, it does. It does. So if you have debt prior to a marriage, that's going to be your debt. It's not going to be your spouse's debt. If you acquire debt during the marriage, it belongs to both of you. You are both responsible for that debt. Now, how creditors deal with that can be a little tricky. They don't want to go in and determine what is separate and what is community. So they're probably going to assume that whosever name is on that debt is the person who has that debt. Right. But there is still that possibility that they might reach in and say, okay, but you're married, and so therefore the other person is responsible.
Wow, that's a twist. I mean, in Oregon, that's a twist.
Yeah, so well, it could happen, but again, it probably won't. What you have on your credit report is what your debt is. And what your spouse has on their credit report is their debt. And the creditor, and this is why I say the creditors probably are not going to reach in and say, well, we're going to tie these together. And now we're going to go into bankruptcy, because if one spouse gets a discharge from debt in bankruptcy, then they are discharged for all of their creditors, regardless of who they are, whether they're listed on their credit report or if they're their spouse's debt through community. But that's if only one person gets a discharge. If both get a discharge, then they get a discharge for everything. But what's interesting about community debt and bankruptcy is something kind of uncommonly referred to as a phantom discharge. Because what happens is, if a creditor, one person gets a discharge, but the other person doesn't, in order for a creditor to collect from the person who did not get a discharge, they're going to have to reach in to what ultimately is community property in order to pay that debt. And because that community property belongs to both parties, they would be reaching into, say, wages or seizing accounts in a bank. And since that belongs to the person who has been discharged, that would be a violation of the bankruptcy discharge. And so they tend not to go after a spouse who has not been discharged.
Staying in bankruptcy, that's just brought up another question. Let's say, I and my spouse have property. Only I filed the bankruptcy. In the bankruptcy, debtors, we're talking, and I say, well, why don't I just sell you my car, or why don't I give you this or give you that? And they say, okay, I'll take it. How does it? I mean, I imagine you just can't sell community property or transfer a deed to community property just willy-nilly.
Yeah, the rules apply strictly to real property. That one spouse is not allowed to transfer real property without the consent of the other spouse. So real property, like I say, is pretty strict. With vehicles, it depends on who's on the title, and you may or may not have somebody on the title, and that may or may not reflect the community property nature of the asset. Yeah, and that again comes back to, where does this generally apply? It applies in bankruptcy. It applies in family law. Right. And we're really going to look at it at the end of a marriage. We're going to look at who owns what and who owned what prior to the marriage, so that we can determine who can transfer what and who can continue to own things.
Okay, let's do that. Let's move to divorce and community property and separate property and community debt and separate debt. And how the heck is that viewed in a divorce? Are there presumptions? Where do they start at when they start to look at that?
So because it's community property, the judge is going to start by assuming that everything that's owned is community property. You're pretty much going to have to prove that something is your separate property. And that can be tricky because if, let's say that you receive an inheritance during the marriage, it doesn't matter if it's before or during the marriage, an inheritance is going to be your separate property. You get a check, you put that check in the bank, and then you spend off of it or you save it, whatever you're going to do with it. When you put it into the bank, if that's a joint account with your spouse, it has now been commingled with everything that is community. So that's where I was discussing earlier. Something can be transformed from separate property to community property if it's hopelessly commingled. If we can track, you received this $10,000 here, you put it into your community bank account, but then you immediately went and opened a separate account and put that in there. Well, now it's preserved. It's still going to be separate property. You can trace where that went. But when the money goes into the account and you spend off of it over a term of years, who knows which of those dollars in that bank account belonged to the inheritance or not? It's hopelessly commingled.
Oh, that makes
another
I was
feature
just going to say that makes sense. And the flip side of that is, what if they have a community bank account, but one person had a car, one person had a house, and they just pay, they both put their wages in it and pay out on that.
Yep. And then we start to have the same kind of thing. So it'll probably affect more with a house than it will with a car. But with a house, say one person owns the house before the marriage, they get married, both people live in the house, and then during the 20 years or so that they're married, both of their incomes are contributing to pay the mortgage on that house. Well, now there's a value to that house that probably is separate property, but there's another value to the house that is probably community property. And a judge is going to have to go in there and figure out, well, how much of it belongs to you, how much of it belongs to you, and then we'll separate it out. And of course, separation of distribution of assets at the end of a marriage is always tricky, especially with a house where you've got one large asset. How are you going to share that equity? You're probably going to have to refinance or sell anyway. So it all gets separated.
I mean, that kind of leads right to my next question was, is community property mean I own 50%, you own 50%? And so, if we decide it's community, I get half and you get half. And it has to go, does it have to go that way?
No, it doesn't have to go that way. A judge making a decision, and we always kind of have to look at it from the perspective of a judge making a decision. The parties can determine what they want to do themselves before a judge makes a decision. They can figure that out. If they want to do one thing, they can do whatever they do. But once a judge has to make a decision, then the judge is going to step in and say, well, what is fair? What is equitable? And that's where we look at who contributed to maintenance on the house, who contributed to the mortgage payments, how much are we going to be affected at the end of the marriage by splitting up the equity in this house? Is the family home that's been in the family for generations, is it going to have to be sold? And that might actually impact the decision on the judge, because then the judge has to make a decision that is fair and equitable. And when he does that, or she, it's probably going to be a she, when she does that, she's going to look at the separate property as the whole property of the family. Even though this other house, the cabin in the woods, belonged to you before the marriage, it's yours no matter what. If we have to separate other assets and there is some kind of an inequity in splitting up those assets, the judge may say, well, I'm going to go back and reach into that separate property, bring it back in and say, we may use this to distribute. And of course, that's more likely going to come up in the terms of, say, an inheritance or a pension or some other financial asset.
Will the judge ever kind of put support into the equation? Yeah.
Meaning a spousal support or alimony. Yeah. It's more likely going to go the reverse. that the judge is going to look at the assets that are available, because that is one of the factors that a judge has to consider in determining spousal support is what assets are available. What was the lifestyle of the parties? What is the need of the party who's intended to receive it versus what is the ability to pay? And if the ability to pay also requires including something that may be separate property, that may be considered as part of that equation in determining what spousal support ultimately is.
Got it.
Mm.
If the spouses either had a prenup or agree, to divide XYZ, is that binding on a judge? It seems like, without some pretty darn good representation by an attorney, a person cannot be sure what is and isn't community property. And there could be some pretty, I don't know what to say, uneven people, trying to do it.
Sure, it could be. And I think that's probably going to come down to how well written is that agreement. Did it consider all the factors it needed to? Is there maybe a termination on the agreement? Does it ultimately lead to a fair and equitable result? Because say, for example, that was a prenuptial agreement, and then after a 38-year marriage, now we've got one party who's left with nothing, with no experience and no education and no job and no money. Well, then that is going to be considered as a factor in determining what is spousal support and what is distributed as assets.
You mentioned the house, the cabin in the woods, which, by the way, was a really scary movie. But
it went in a weird direction.
Yeah. What if that cabin in the woods is in the woods in Oregon? Is that property considered community property?
The question is, what is the state that has jurisdiction over the divorce?
Let's say Washington does.
That's how I'm answering the question. There is if Washington has jurisdiction over the divorce, then that separate property, and again, if it was separate property, it's separate property, right? So if it came into the marriage, it was owned prior to the marriage, it's separate property regardless of where it was. If it came into the marriage during the marriage, then, and the divorce is being done in Washington, then I think, and I've never faced this issue in court, but I think that you're going to find that it's community property because you've chosen Washington as the state that has jurisdiction over your divorce.
That makes that's complete sense. I mean, to me, that makes complete sense. Little bit on before we kind of end, are there certain properties that aren't community property that or maybe are community property that that people should think about because they think that's mine? Like I'm kind of thinking in terms of a pension or deferred wages or royalties that are going to come later. You can't have that. That's mine. That doesn't, community property doesn't count that.
Yeah.
Does
And
it?
some people go into a divorce with that mindset, and they may be finding that it's not necessarily the way that they expected it. Yeah. When we divide, say, a pension, we're going to divide a pension based on what is the marital portion of that pension, so that the ex-spouse has a right to, say, 50% of the part of the pension that was earned during the marriage. So we can separate that pension, even a pension or a 401k, we can separate those out and say, well, you earned this much prior to the marriage, you're going to keep that part. Then everything you earned during the marriage, that's what we're going to split, including interest and earnings on everything. And then when you separate, and that's an interesting little question too, is at what point do we break that? And in Oregon, the courts have said we break it at separation. In Washington, it's the parties are going to decide at what point we make that split, and then everything that's contributed to the account afterwards belongs to the party who owns the account.
So I'm does the community property, let's say the judge makes an order. You get this, you get this, you pay this, you pay this. A couple questions on that is if, let's say the house was in one person's name, but was declared community property because, it was maybe bought during the marriage, but just one of the spouses bought it. How do they fix that? Is there anything special, that maybe a non-community property state would have to kind of fix that, or is there? Maybe it's just the same. I don't know. Just wondering how they get rid of the property, especially, or sell it.
Yeah, it can be challenging. It can be challenging, and in fact, we see cases all the time where people they're not acting quickly enough for one party's taste, or they're not doing things that they had agreed to. And during COVID, especially, it was very tough for people to get financing under certain circumstances. And so it comes up. What do you do with this house that has $500,000 in equity, and it's the only thing that the parties own, but it's where somebody lives? We need to change the title from one person to another, and we need to figure out the mortgage and get the mortgage so that it's in one person's name. And usually the only way to do that, well, a couple ways, like you said, Steve, we can sell the house. That'll solve the problem. Or if it's possible, you may get the person who's going to continue living in the house to refinance. And then if they refinance, then that fixes the mortgage issue. And then all that's left is that title issue. And the title issue is actually pretty simple. It really is just some simple paperwork that we get signed, notarized, and filed with the county. It's pretty simple.
Yeah.
As to how we do it in a community property state, I'm not sure.
No, that makes sense. So let's say your spouse is ordered to pay community property debts of X, Y, or Z, and then they don't. Does community property status get split so you don't have to worry about it, or how does that work in a community property state?
Well, and that kind of segues us back into bankruptcy a little bit too. So you've got a debt that belongs to both parties. It's community debt, but in the divorce decree, it's been assigned to one party and not the other. There's also going to be a phrase, a paragraph in your divorce decree that is a hold harmless claim. And what that says is that we recognize that this debt now belongs to one person and not the other. The creditor may or may not see it that way. And so when they're unable to collect from this person, they may go to the other person to try and collect. And they may garnish wages or seize bank accounts in order to do that. And they have a right to do that. But now this person has paid some of this debt. And now instead of this person owing that money to the creditor, they're going to owe it directly to the other spouse. And now we come back into bankruptcy, because what happens to that? Now let's say that this person who the debt is supposed to belong to files for bankruptcy. Well, they get a discharge, and they get a discharge on that debt as to that creditor. And so they don't owe that creditor anything. The creditor can still come back to the ex-spouse and collect that. Now, that debt that is owed from one party to the ex-spouse continues to be owed to the ex-spouse. That is something that is specifically not dischargeable in a bankruptcy. If it's pursuant to a divorce, then that and that's especially why we have that hold harmless clause in those divorce decrees, to make sure that the spouse that's not supposed to be responsible to that debt is not responsible.
So then the spouse could actually go and sue the other ex-spouse to get a judgment for the money. Can they go back to the court and say, hey, judge, this person isn't paying me, do something about it?
That's exactly what they can do. And then they have the rights of a creditor, and they can go in and garnish wages or seize bank accounts if that's what it takes. Yeah.
So going down to bankruptcy again.
Yeah.
Are there filing, issues that, because it seems to me there might be, that, affect, community property rules that affect filing for bankruptcies?
There are, yeah. And I want to, I want to talk about the community debts and the community property as well. When you file a bankruptcy, and of course, if the spouses are filing the bankruptcy together, it doesn't matter. Whatever belongs to both of you belongs to both of you, and it's all going to be declared in your bankruptcy filing. But it's when one spouse files and the other doesn't. And in fact, it even extends to when one spouse files and the ex-spouse doesn't, because you can't, once you're divorced, you can't file together. There's still that link with community debt, and there could be a link with community property, and that needs to be cleared up. But when the basic scenario, one spouse files, the other spouse doesn't. And that's most likely to come up when the marriage is new and the one spouse enters the marriage with significant separate debt, because otherwise it doesn't make sense for you not to file together, because if then the other person has to file, you're going to have to pay all the fees and everything again. That doesn't make sense. So you should probably be filing together. But if you are filing separately, and you're allowed to do that, you still have to consider all of the assets that are community property as your assets. So even though your spouse has a car and your spouse has a ranch in the Philippines, you still have to count all of that as your property. And it could affect your ability to file between a Chapter 7 or a Chapter 13. The ability for you to exempt and keep some of those assets. And it's possible your spouse can lose some assets. And I've actually seen where one spouse filed, then they got a divorce, and the ex-spouse lost a car because it was considered community property and an asset of the bankruptcy estates. So you've got to be really careful about what you own.
Yeah, that sort of goes back, I guess, to the while you were married. Do they look at that kind of thing? Well, you bought the car before you were married, so we're not going to go after the,
Yeah, it does. The community property. The way that community property is addressed in a family law case, it will come back, and that's how it will be addressed in a bankruptcy case.
So if someone comes into you, and I guess maybe this is probably it depends answer, but someone comes into you, and they are married, but they're clearly going to get a divorce, and they say, well, when should we file? Should we file now? Should we file during the divorce? Should we file after the divorce?
Yeah.
What do you say?
Well, what's going to happen? That's what I'm going to start with, is what's going to happen to both parties. Do you both need the protection of the bankruptcy? If one person, after the marriage, after the divorce, if one person is probably not going to need to get to file bankruptcy, well, then maybe you want to file the divorce first and then come back and do the bankruptcy. I think more likely than not, you're going to want to do the bankruptcy, get the bankruptcy done, and then file the divorce. When you file a Chapter 7, which most cases in Washington end up being Chapter 7 cases, you file a Chapter 7 case, you're going to get your discharge in probably about 3 months after you file your case, maybe a little more. And that's kind of a magic number, that 3 months, because when you file a divorce in Washington, you have to wait 3 months before the divorce can be finalized. And another part of this is where they are married together, is that a bankruptcy filing that exists at the time of a divorce means that the family law judge is unable to deal with assets and distribute those assets because they are tied up in the bankruptcy. So that bankruptcy will either need to be concluded before you finalize the divorce, or you're going to have to get permission from the bankruptcy court to distribute those assets. So they all go together. And so the advice is more likely going to be, let's file the bankruptcy first, So you file it together. You're married, you can still file the bankruptcy, because once the divorce happens, you can't file it together. You have to file separately. And if you're both going to file anyway, why pay all of the attorney's fees and the filing fees again when you can just do it together?
That makes 100% sense.
Yeah.
We're unbelievable that we're running out of time, but we are. But I do have one more bankruptcy kind of question, because I was thinking as you're going through. I know that when you're in a bankruptcy, there are some, what they call, I think they call them exceptions, where you get to keep some of your property.
Yep.
That whole keep some of your property thing made me think, well, what property? Does community property kind of get entangled in what property exceptions are allowed in a bankruptcy?
Yeah, it does. It does. And that's what I was saying earlier, where when you file your bankruptcy petition, you're going to claim, you're disclosing, here is all of my property. And you have to include all of the community property, everything that belongs to you and your spouse. And in order to keep any of those things, they have to be covered by an exemption. And if something is not covered by an exemption, even if it belongs to your spouse and not to you, according to how the two of you agree, it is at risk of being lost in the bankruptcy. So you need to be, that's why we need to be careful about making sure we one, know that you're married and we know what all of the property both you and your spouse have is, and then three, making sure that we're able to cover everything with the exemptions. Because if not, then we may need to do something else, like filing a Chapter 13 instead of a 7.
That makes 100% sense. Well, I mean, we're going to have to conclude, and this is just been a great topic. Is there anything that we haven't talked about? You might add just something that if you're going to be aware of anything, be aware of this kind of a thing.
Yeah, I think probably what I see affecting people more than anything else is that question of, if you're filing a bankruptcy, you need to be sure that you're including all of your spouse's property as an asset. I'd say why that's probably your biggest risk is, let's say you file your Chapter 7, you say, here's all my assets, and you leave it at that. And then later, the trustee discovers that you were married, because for one reason or another, there are other places where you're going to have to disclose things. So the trustee says, well, you're married. I see you're married. And he's going to ask, did you include all of your spouse's assets as well? And if the answer is, well, no, because they're my spouse's assets, now all of a sudden the trustee is going to be interested, because it now looks as if there are assets that can be liquidated and paying off your creditors. And you just need to plan for that.
Okay. Can you have so much money or so much wages, or that it may actually kick you out of being able to file a bankruptcy?
Well, this is a half-hour topic that you're addressing here, Steve.
That's the next half hour.
But the short answer is yes. Like I said, most bankruptcies that are consumer bankruptcies that are filed in Washington tend to be Chapter 7 bankruptcies. If your income is above a certain threshold, you're not going to be eligible for that, and you're going to have to file a Chapter 13. And chances are, if that's the case, then there's probably not a problem to that. What there is, though, is a risk that you may lose some of those assets to the creditors, and that's why you have to be careful. Whether it's a 7 or a 13, that risk is there.
Well, I'm going to take you up on your word about the next half hour, because I would love to just have a bankruptcy issue and just all the intricacies of getting a bankruptcy in Washington. But today we're out of time. That is really unfortunate. Thank you, Michael. I mean, I really appreciated talking, because you talked this was very straightforward, and you made really complex stuff understandable. And if you made it understandable to me, I'm sure you made it understandable to everybody else. So again, Michael, thank you so much for being here today.
You still should check with an attorney.
Oh, yeah.
Even if it sounds easy, still check with an attorney.
It seems to me like it is more important, if not anything else, to check with an attorney when you're in a community property state, because you may, in some other states, if you own it, if you don't own it. And here you may not. I mean, just because you don't know the law that well. So, Again, thank you so much for being here today.
Thank you, Steve.
Anyone else, I want to thank you as well for being here. And anyone with any further questions on today's topic, you can post it here. We can get you connected with Michael. And until next time, as always, stay safe, stay happy, and be well. See you next time.